Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving professional negligence, a key topic in tort law under FLK1. Let's dive in. A group of investors were actively seeking to acquire a company. During negotiations, they were provided with the company's annual financial reports, prepared by the company's accountants. To verify the reports, the investors instructed their own accountants to conduct a review. No issues were identified. Relying on those reports, which suggested strong financial performance, the investors proceeded with the acquisition. Several months later, they suffered substantial financial losses when it became clear that the company was worth significantly less than expected. They now ask whom they can sue for the losses. Who is most likely to be liable? A. No one. The investors relied on their own accountants, and there is no evidence of negligence. B. The company's accountants. They owed a duty of care to anyone who reasonably relied on their reports. C. The investors' own accountants, because they owed a duty of care to the investors. D. The company's directors, because they passed on inaccurate reports. E. Both accounting firms, because the investors relied on both to ensure accuracy. The best answer is A. No one. The investors relied on their own accountants, and there is no evidence of negligence. Under English tort law, particularly the principles established in Caparo and Dickman, 1990, an accountant, or other professional, owes a duty of care only to those for whom the work is specifically prepared and reasonably foreseeable as relying on it. In Caparo, the House of Lords held that company accountants preparing statutory reports owed a duty to the company, not to third parties or potential investors. In this case, the company's accountants prepared the reports for the company, not for external investors, so no duty of care was owed to the investors. The investors hired their own accountants to verify the reports, and relied on their advice. There is no indication that their own accountants were negligent, so no breach of duty arises from that side either. Since neither party can be said to have breached a legal duty of care toward the investors, no one is legally liable for the losses under the tort of negligent misstatement. Scenario 2. A group of investors were actively seeking to acquire a company. During negotiations, they engaged an external law firm to conduct legal due diligence. The firm produced a report highlighting a potential legal risk. Concerned by this risk, the investors decided not to proceed with the acquisition. It was later discovered that the identified risk did not exist. The DD report had been prepared by a trainee solicitor at the firm, and no supervising solicitor had reviewed or corrected the analysis. The investors are now angry and ask whether they can sue the law firm for the loss of a potentially profitable opportunity. Can the law firm be held liable? A. No, the report was only advisory, and the investors made their own commercial decision. B. Yes, the law firm owed a duty of care and may be liable for negligent advice. C. No, because there was no written contract guaranteeing the accuracy of the legal report. D. Yes, but only the trainee solicitor can be held liable, not the firm. E. No, because legal risks are always uncertain and cannot give rise to liability. The best answer is B. Yes, the law firm owed a duty of care and may be liable for negligent advice. When a law firm is engaged to provide professional services, such as legal due diligence, it owes a duty of care to its client to exercise reasonable skill and care, even if the work is performed by a junior team member like a trainee. The client is entitled to rely on the legal advice provided, and if that advice is negligently prepared, the firm can be held liable for professional negligence. In this case, the investors relied on the due diligence report when deciding not to proceed with the acquisition. The report was inaccurate and identified a non-existent legal risk. The fact that it was prepared by a trainee solicitor is irrelevant to the client. The firm is liable for the actions of its employees. Supervision failure by senior solicitors may also be part of the negligence. This aligns with the principles in cases such as Ross v. Caunters, 1980. A solicitor can be liable for loss caused by negligent advice, even where the breach arises from an oversight. Scenario 3. An investor actively sought another business opportunity. Before proceeding with a new investment, he instructed a bank to prepare a creditworthiness report on the target company. The bank issued a written report but included a disclaimer stating, "This report represents our opinion as at the date of issue. We do not guarantee the company's ongoing creditworthiness." Relying on the report, the investor proceeded with the acquisition. 2 years later, the company became insolvent. It was later discovered that the bank had overlooked a substantial existing debt when preparing the report. The investor now seeks to recover his losses from the bank. Can the bank be held liable? A. Yes, because the investor reasonably relied on the report when making the investment. B. No, because the bank owed a duty only to the company, not to third-party investors. C. No, because the bank excluded liability by clearly disclaiming ongoing responsibility. D. Yes, because the omission of the debt made the report negligent, and the disclaimer did not excuse that. E. No, because the loss arose 2 years later and is too remote. The best answer is D. Yes, because the omission of the debt made the report negligent, and the disclaimer did not excuse that. Under English tort law, a professional such as a bank may owe a duty of care for statements made in a report, especially when they know the client, here, the investor, is relying on it. This falls within the Hedley Byrne and Heller, 1964, principle of negligent misstatement. In Hedley Byrne, the court also confirmed that a defendant can avoid liability by including a clear and reasonable disclaimer. In this case, the bank added a disclaimer. However, the language of the disclaimer only protects the bank against claims about future developments. That is, it is not responsible for events after the report date. The investor's current complaint is about the bank missing a major debt that already existed at the time of the report, which is a present factual omission, not a future risk. A disclaimer that merely limits future liability does not shield a professional from liability for failing to carry out their duty competently at the time of the report. This table outlines the legal principles we walked through. In Scenario 1, no duty of care arises where the investors relied on their own accountants, not on reports prepared for someone else. Professionals owe duties only to those for whom the advice was intended. In Scenario 2, a law firm owes clients a duty to act with reasonable care, and is liable for mistakes made by its junior staff. Clients can rely on legal advice regardless of who prepared it. In Scenario 3, a disclaimer limiting future responsibility does not protect a professional from liability for negligent omissions about existing facts, such as overlooking a major debt at the time of reporting. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.